2017 CF 15684, State v. Nelston, back from our recess. Simmons, is defense ready to proceed?
Judge, we need just a moment.
Sure.
Judge, may we have a moment to just step outside to discuss something and come back in?
Who are we talking?
The attorney's here.
Okay.
We just need to discuss something and be sure that we all can hear each other. And
Sure.
it's supposed to be right now.
Okay, go ahead.
Thank you.
I'm not buying none of that nonsense. I want to know something. I'm going over here and I'm going to say and that's it. This is due process. Yes, good. Whatever you want. Because if you're afraid of the truth coming out, you need to find another job. I know. I want to testify up there. Go up there and ask me my question. That's it. You're restraining me. You're denying the due process of law. I understand what I'm doing. You don't understand. Yes. Listen, I want you to ask me the question. That's why I went up there and you're afraid to ask me the question. I want to go up and testify and you ask me this question. No, not what you think. Due process of the law. I get the right to say what I want up there. Now let me say what I want to say. Scared to death.
Would you like to?
Yeah.
Judge, at this time, Mr. Nelson would like to have a Nelson hearing. He's,
I beg your pardon?
Mr. Nelson would like to have a Nelson hearing. He's
Nelson?
unhappy with his representation at this point.
Mr. Nelson, did you just hear what Ms. Moore said?
Yes, I did, Your Honor.
Okay, did you agree with that?
Yes, I did, Your Honor.
Well, tell me what the issue is.
The single issue is this. As I told the lawyers earlier today, as I have told them for months and months, I want to get up there and I want the jury to understand. I want to go up there and testify to the question as to what this 25 years in prison has done to me and what it's going to do to me in the future. What I want to get up there and let them know what is going to happen if I'm given life and no parole.
Let's step back for a moment. My understanding from what Ms. Moore just said, that you want to have a Nelson hearing, you understand that there happens to be a case with the same last name of yours.
Yes.
That involves allegations regarding ineffective assistance of counsel. You understand that? That's what a Nelson hearing is asking for.
Yes.
Okay. So just in layperson's terms, what is it that because you just took the stand.
I know.
Correct? And you took the stand during the first phase of the trial.
They won't ask me a question. I want to say something.
So your issue or your dissatisfaction with your attorneys is they're not asking you one specific question. I mean, they've asked you questions now twice. You're saying neither the first time you testified, when Mr. Lahr asked you direct and then Ms. Moore just did direct. Neither time did you answer the question that you believe should be asked.
That's correct.
Is it just one question?
Actually, two questions, sir. It's very brief. Very
Okay,
brief.
so you've talked with your attorneys about the two questions?
Yep.
Okay. And Mr. Lahr, Ms. Simmons, Ms. Moore, I see your client is holding a piece of paper. Have you seen this paper with the two questions?
Yes.
Okay. And do you agree with Mr. Nelson that you haven't asked those two specific questions? Mr. Lahr and Ms. Moore, you were the parties that did direct. I mean, just take a look at the piece of paper. I just want to make sure there's. I want to hear your position as to whether you've asked those questions.
Judge, I don't remember whether the first question was asked in guilt phase. I know for certain I did not ask either of these questions as worded based on our conversations prior to his testimony.
Okay. Mr. Lahr, anything to add to that?
No, neither question was asked on the first stage of the trial.
All right. Mr. Nelson, you have that piece of paper in front of you. It's up to you. In order for me to engage in a full Nelson hearing, I need as much information as I can. Can I see the specific questions that you want asked of you?
Yes, of course you may.
All right, just hand that to the deputy. Thank you, deputy. Okay.
Judge, may we also see what the questions are?
We don't think they have a standing in the trial, so we would ask that not be approved.
I'm going to deny that request at this time, Mr. Nunley. All right, so Mr. Nelson, I've seen these questions. Counsel, Mr. Lahr, Ms. Simmons, Ms. Moore, you've seen these questions, correct?
Yes.
Okay. And have you had an opportunity to talk with Mr. Nelson about these questions and whether you believe they should be asked and whatever your opinion is, why, the basis for your opinion? Have you had that discussion?
Yes, we've discussed it, yes, Judge.
All right. Mr. Nelson, is that correct? Did your attorney talk with you about these questions and give you their advice on?
They simply won't ask them when I'm up there.
Did they explain to you why they haven't asked you these specific questions?
No. I know they don't want me to answer. They don't like the answer that I'm going to give.
So you haven't had a chance to hear your attorney's explanation as to why they don't want to ask you these specific questions?
Because they have their own agenda.
What I mean is, have you talked to them about what their reasons are?
Yeah.
They have given you reasons.
Yeah, they're giving me reasons as to why I shouldn't go up there and answer those questions. But I mean, it's due process. I want to go up there and answer them. They're important to me. I mean, it's the crux of the entire trial. I mean, that is those two questions, sir, is Your Honor, is the bottom line of what happened to everything in this trial and what I am and what this is. Without asking that, it's like, it's silly.
So your attorneys are giving you advice that they don't want to ask you these questions. They don't think it's in your best interest.
Right. I mean,
Have you had a chance to think about that and why they're giving you that advice? They are retained to represent you, to represent your best interest. You understand that's their job?
yes, sir, Your Honor, I do.
But you want to disregard their advice and have them ask you the questions anyway.
I've been thinking about this for over a year. I mean, I'm very determined in answering those two questions, sir, regardless of what anybody, the state or the defense or anyone thinks. Of course, I'm going to be the court decorum and be respectful and everything. I just want the answer. This is important to me. This is why I'm here. This is the only reason I wanted to testify. Otherwise, I wouldn't have testified at all. I've been waiting for someone to ask me these questions, and no one wants to go near these two landmines.
Okay. Mr. Lahr, what's your response to Mr. Nelson's allegations and thoughts?
Well, we have tried to give them sage advice, and we believe we have asked all questions that would be able to be asked that are relevant. Don't believe that at least in the second one, that would be something that would be relevant or something that we could actually get in as admissible under the current evidentiary rules.
Judge, just to clarify, prior to Mr. Nelson's testimony in the first phase of the trial, we provided the court with a case, Holland, which is 916 Southern 2nd 750, about the defendant's right to testify. And it's based on that case that we don't believe that the answer to the second question is an admissible response. As to the first question, I can tell you that was a miscommunication between me and Mr. Nelson. I asked him, or without going into details, I thought that he did not want that question asked. As to the second question, we don't believe it's an admissible response, and therefore we don't believe that we have to ask it under the rule that's expounded on in Holland, which is that case that we previously provided. According to that case, we can't limit his testimony for strategic reasons, which is not what is happening here. We are indicating that we don't believe that the response to the question will be an admissible response, and therefore we are allowed to not ask that question under Holland. And that's a 5th DCA case. We believe it's essentially directly on point. And so as to the first question, if Mr. Nelson is demanding that we ask it, we can do that if the court would allow us to recall him. As to that issue, we have explained that we believe there's sufficient evidence to make the argument that he wants made, but that specific question was not asked. That was based on a miscommunication with Mr. Nelson and I.
So then to be clear, Ms. Moore, your position would be you and Mr. Nelson are in agreement. If he wants you to ask the first question, we'll put him back on the stand. You can ask that first question.
That's correct, if the court allows.
Okay. And then the second question, the case that you referred to, I don't happen to have it handy. I do have a vague recollection of that name.
Can we get the site to that case?
Yes, we provided you a copy previously, but it's 916 Southern 2nd 750.
Right, and the defense argument is, under that case, in discussing the defendant's right to testify, actually, do you have a copy of that case?
I don't have it printed. I can give Your Honor a general explanation of the case. It was a circumstance where the individual wanted to testify. The defense attorney did not want him to testify at all, and essentially said to him, you can get up there and give an allocution. I'm not going to ask you any questions. And the judge got involved and said, either you answer the questions that the defense attorney asks, or if they don't ask any, you represent yourself. And the court found that was improper to force someone to choose between the right to counsel and the right to testify.
What's the citation again?
It's 916 Southern 2nd 750. I believe Ms. Simmons is trying to print it for the court. It goes on to explain that they go through in that case the things that the defendant wanted to testify to. And the court found that the things that were admissible, the defense attorney had to ask the questions in order to elicit those responses. They did find that the things that were not admissible, the defense attorney did not have to ask, and that did not impinge on his right to testify. That's what we're basing this decision on. The question and answer that Mr. Nelson would like to give is not admissible under the rules, and so based on that case, we're not required to ask it. And that doesn't infringe on his right to testify, which he has done already twice.
Here, I have a printed copy of Holland.
Okay. Thank you. Ms. Moore, where in this decision is the portion of the opinion addressing the issue before the court?
I don't have the case. Judge Ms. Simmons may have printed the wrong case.
Yeah, I don't see anything about, at least certainly nothing that's addressed in the head notes. That's why I was asking if somewhere in the body it addresses this right to, defendant's right to testify in the context of counsel's opinion that questions have been illicit, inadmissible evidence.
Judge, I apologize, we're just quickly looking for the case. I think we may have had the wrong one.
Judge, if I may, while counsel is looking for their case, we're concerned over a written communication between the defendant directly to the court that the state's not a party to. That respectfully appears to be an ex parte communication. And we are in, I believe, an odd circumstance, to say the least, but I'm beginning to feel like the odd man out over here, that everybody else knows what we're talking about but us. And we're at a substantial disadvantage because we do not know the substance of what is going on, because we do not know what Mr. Nelston is talking about. I mean, we can guess, and I suppose I might have a decent chance of being right, but I don't know that, and I don't want to be guessing about anything in a capital case. And for that reason, I would again renew the state's request that we be allowed to see the question at issue.
Your Honor.
And, Your Honor, I don't know what it is. It may be exculpatory, I don't know what it is, but it may be inculpatory. Or it may be evidence for all we know, but at this point, to restrict that communication between the defense and the court is improper, and we would suggest that it is entirely proper for us to see it and to know what we're talking about so we can respond appropriately.
What would be this? And Mr. Nolly, I understand what you're saying, and I can assure you that what has been handed to me will be made part of the record. It will be made part of the record. So I know that doesn't address your immediate concern, but this will be part of the record because this is what I'm having the colloquy with the defendant. But tell me, Mr. Nolly, in terms of, for purposes of a Nelston inquiry over a defense objection, do you have authority that would indicate, because if the court rejects this and finds that these questions are not to be asked, if that's the ruling, then this will be part of the record and we'll move on. If the question is asked, you'll certainly have an ability to do cross-examination, and then you will see it.
But Judge, Nelston hearings need to be based upon evidence that is presented under oath and potentially subject to cross-examination. And
In a Nelston hearing?
potentially, yes, Judge, because what we have here is a communication that's not, I mean, let me back up. In a Nelston hearing, the defendant would be sworn, you would be placed under oath.
He is sworn, and he is under oath.
But this written statement is not under oath. The written statement, written questions rather, that have been provided to the court at this point in time are hearsay. They are not under oath. They are not subject to cross-examination. They're being kept secret. And that is not how a Nelston hearing, at least in my experience, is ever handled. I have never seen a Nelston hearing in which the defendant did not testify under oath and articulate and elaborate upon his reasons for seeking to discharge counsel. I have never seen it done and never known of it being done by written messages passed.
Mr. Nolly, I agree that I've never seen it, but that still doesn't answer the legal question, and that is I've also never had a defense attorney object to the state being privy to what the basis for the Nelston inquiry is. And so I just ask you again, if you find a case you want me to look at, I'll be more than happy to look at it.
The bottom line is it is an ex parte communication, and that is not appropriate.
Well, I agree at this time, I'm not showing this to the state. It's here in my hand. It will be part of the record. And I'll say one more time, if you find a case in this context, the court entered an order that allowed certain ex parte motions to be made by the defense. So the fact that it's maybe classified as, quote, ex parte, close quote, doesn't mean that's never permissible under any circumstances in any situation.
But Judge,
But at any event, we have a jury sitting back there now for almost an hour. So I'm going to read this Wilson case. And again, Mr. Nolly, if you find a case, then I'll be more than happy to take a look at it.
Judge, I apologize for the misstatement before, but for the record, it's Wilson versus State, which is 12 Southern 3rd, 292, out of the
Right.
4th DCI.
All right, thank you. Did you get that citation to the Wilson case, Mr. Nolly? Or do you have a copy?
we have it, Judge.
Okay. All right, who's going to respond for the, I've now read the Wilson v. State case. I need someone from the defense to respond to Mr. Nunnally's argument that the state's entitled to see this piece of paper that has the two questions that Mr. Nelson wants to be posed to him by his attorneys.
Well, at this point, it's confidential attorney-client privileges. He's asking us to be able to do, ask these questions. They do not have a dog in the fight. It's like any time we ask any ex parte hearing, or if we do a motion to withdraw, and we can't do it because there's any confidential information that goes forward. In this particular case, that communication was intended to be only communication between us and our client. In order for the Nelston hearing to proceed, we reluctantly gave the court this document so you can see exactly what he's talking about. So again, they don't have a right to it. It is an attorney-client communication, and we don't believe that's waived by having to get that over at this point.
Mr. Nonnally?
Judge, if you read the Wilson case that the defendant relies upon on page 3 in the second column, the court specifies what the defendant wanted to testify about. He testified, apparently, the defendant identified the questions that he wanted, or the things that he wanted to testify to. The defense counsel told the court, and I'm quoting, that she did not want to ask Wilson any of these questions, and goes on and gave her reasons for doing that. And the court ended up saying that, among other things, counsel may not cut off a defendant's testimony for tactical reasons without the defendant's consent. It goes, but coming back to the threshold issue, there is no attorney-client privilege anymore as to this document, if there ever was one, because it's been made available to the court. Under the very case the defendant is relying upon, the questions that that defendant wanted asked.
Not only I understand your argument. Mr. Lahr, what's your response that has been provided to the court and therefore any privilege is waived? And let's set that aside for a moment. To make sure I'm reading this correctly, I'm going to read the question to Mr. Nelston.
I'm going to object, Your Honor. Yeah, that basically covers exactly why we're...
How am I to make my record clear for the Nelston inquiry unless I make sure I understand exactly what his allegation is, which is always done in open court, verbally, by the defendant to the court. I have received requests for Nelston hearings in writing, but then it's been my practice, and I believe the practice of many judges, to engage with a colloquy and specifically have the defendant place on the record exactly what the allegation is. So when the allegation are these two questions.
And if I might be heard, my suggestion is you can ask him, he provided that to you, and he told you this is what the questions he wanted to ask. That sufficiently tells you that he is, since it's in his handwriting, that he wrote it and that's what he wants asked. So I don't think you need to make any further inquiry in open court that is the questions he wants asked. And again, it essentially defeats the purpose. It's ex parte communication, that we can have, that is not required. Again, I know the state said he's never had, the path before, neither have I. But also, I would also say that they're not really entitled, because it's not evidence, and it's not something they can cross-examine on. That never happens, because again, they do not have a dog in the fight. This is basically him saying that he has a problem with our representation on that specific issue. And since he provided it in writing and told you that was his, the questions he wanted to ask, and there was no disconnect from the time that the court deputy took it from his hand and brought it up to the court, there's no reason for you to announce on the record what it is. And additionally, you said you would make it part of the record. That is sufficient for that.
All right. I disagree. I'm persuaded hearing from both sides by the state's argument for a variety of reasons. I do believe in a Nelston inquiry, there's a waiver of any allegations regarding ineffective assistance of counsel by the defendant bringing up the issue. Mr. Nelston has raised this issue. He has given this to me in writing. I asked for that just because I wanted to have it in front of me as to what these questions were. I am going to read it on the record because I want to make sure that I'm reading this handwriting, that I'm not sure whose handwriting this is, but I want to make sure that I understand what the questions are so I can make a final decision on the Nelston inquiry that's before me. It is going to be a part of the record because it's being a part of the record. It's not privileged. It's not privileged now. It's not going to be a privilege when it's part of the record. It's going to be part of the record.
Your Honor, if I could ask, there is one other way to do this, and then you can make sure that it's for us to have an in-camera hearing where everyone's cleared out. The only one
I'm going to deny that request. All right, Mr. Nelston, I read your first question as follows. Did the warden, D.L. Young, is that correct?
Yes, sir.
Offer you an agreement in concern to your colostomy contradicting the agreement he laid out to Senator Sanders?
Correct.
And number two, how has being treated like an animal affected you? That's correct. All right, I've just read this. Mr. Nolan, do you want to approach and actually see this?
No, Your Honor.
Okay. All right, Mr. Nelston, based on what Ms. Moore stated, it appears to the court that, and I don't know if have you had a chance to talk with her about the misunderstanding, and now she's indicated she's going to ask you the question.
Yes.
Okay, so there's really no issue with the first question, is there?
None.
Okay. To the extent there is an issue, I would find that I do not believe that Ms. Moore was ineffective in not asking this question. I think it was simply a matter of misunderstanding that has now been resolved, and it's going to be asked when Mr. Nelston gets back on the stand. So I don't believe there's any basis to find any reasonable cause to believe that Ms. Moore has been ineffective for not asking that question up to this point. With respect to question two, the court has confirmed with Mr. Nelston what the question is. I have also reviewed the Wilson v. State decision. The court believes, reading the Wilson decision, there is a statement that talks about the defendant's right to testify, this is in the opinion, includes the right to testify fully without perjury to matters not precluded by a rule of evidence. This is a question, so there's nothing that's been raised by the defense, nothing before the court for the court to conclude that Mr. Nelston is going to commit perjury by answering this question. So that aspect of the limitation on the right to testify fully is not applicable. The statement to matters not precluded by a rule of evidence, I believe that that is really for the benefit of the opposing party, not the defense, meaning that just because a defendant wants to testify, that defense counsel could ask a question which might be objected to by the state because of an evidentiary rule that precludes it, and that objection might be sustained, and therefore the defendant would not be able to testify. However, this opinion does not hold. I would also note this is somewhat dicta for the holding of the opinion, which basically the holding was that it was inappropriate to force the defendant between choosing to exercise his or her right to testify, or the other choice, if you're going to testify, you have to testify without counsel. And that is really what the holding is. And so that statement is dicta at best, but in any event, that dicta, I believe, applies for the benefit of the opposing party. So I do not believe that the defense counsel's belief that the response to this question may be inadmissible is something that the defense counsel can assert as a reason for not asking the question. That will be up to the state to decide if they object to the question, and then I will make a ruling based on the state's objection. However, reading this case and reading this question, I don't believe it was ineffective assistance of counsel. There's no reasonable cause to believe it was ineffective for Mr. Nelson's attorneys to decline to ask this question up to this point based on the Wilson v. State case. So I don't believe there's reasonable cause to believe defense counsel has been ineffective up to this point, and so therefore I'm not going to discharge counsel for failure to represent Mr. Nelson in an effective manner based on what's occurred up to this point. Mr. Nelson, however, going forward, given the court's ruling, defense counsel needs to ask both questions of Mr. Nelson and I will give Mr. Nelson and counsel an opportunity to confer one more time, but if Mr. Nelson takes the stand and after consulting counsel still wants both of these questions asked, then I do not believe that the Wilson v. State case gives defense counsel a right to override Mr. Nelson's decision in that regard. All right, so Mr. Nelson, you take a moment with your attorneys to talk about what the court just ruled and decide how you would like to proceed.
Judge, I've spoken with Mr. Nelson. I have no problem with recalling him and asking the questions that he has asked, and the court is now requiring that I ask. To be clear, the response that I expect to be non-responsive to the question. I also expect that it would be objectionable and inadmissible under the rules. So I can tell the court that I anticipate that I will object to the response, which I believe is appropriate for me to do under the rules of procedure. Additionally, if the court allows the extent of the response, it would be an inadmissible argument for the state to make under the rules, and I understand that part is couched because we don't know the answer yet. But I think it's important that the court know that whatever the response is going to be, I intend to object based on our conversation, and that this, if it ultimately elicits an inadmissible response, the state still cannot use that response to argue inappropriately in closing.
Right. The only thing I'm addressing right now, so without prejudice to other issues that might come back, is whether Mr. Nelson is going to come back onto the stand. Just to be clear, because Ms. Moore, you stated that I'm making you ask that question. I'm not. Mr. Nelson, you understand my rulings up to this point are just ruling on these issues. You understand you do not have to go back on the stand and have your attorneys ask either of these questions. You understand that?
Yes, sir.
Okay. And did you just hear everything that Ms. Moore indicated?
Yes, I did, Your Honor.
Okay. And so until I hear the question, until the question's actually asked and an objection is actually made, then I'm going to make my ruling you understand if an objection is made by your attorney, the state attorney, if I sustain it, then you will not be allowed to answer. You understand that?
Yes, yes, Your Honor.
If I overrule it, then you will be allowed to answer.
Correct.
So do you need any more time to talk with your attorneys about whether you want to testify?
No,
Okay. Do you need any more time to think about whether you want to testify?
no, Your Honor.
And then now that the court has made these rulings, and I didn't find reasonable cause to believe that your attorneys have been ineffective, you understand that?
Yes, sir, Your Honor.
You understand that these attorneys are provided at taxpayer expense.
Oh, yeah.
You do have a right to retain different attorneys at your expense. Do you understand that?
I understand, Your Honor.
Okay. Do you have any attorneys that you want to replace your current attorney?
No, I'm happy with the counsel I have. I just wanted to testify to, due process, just be able to say something meaningful at a meaningful time. And they're trying to gag me.
All right. And you also understand you have the right to represent yourself if you choose.
Yes, sir.
Okay. At this point, do you want to represent yourself, or do you want to stay with the attorneys that are currently representing?
I'm willing to stay with the attorneys I have throughout the rest of the trial if they're just, please, willing to just ask me a couple of questions on that are very pertinent to this case.
Okay. All right. What I've done is I have put an exhibit tag on this. It's called Defendants R. It's not going to be admitted into evidence. It just has for identification only, so it's part of the record.
Yes, sir.
And so who is going to be inquiring? Ms. Moore, are you going to be inquiring? Okay, so why don't you come forward then so I can give you Defendants R? Yes. And then Mr. Nelson, if you could, the deputies will assist you take the stand again.
Thank you, Your Honor.
All right, sir, this time you can be seated. I'm just going to I'm going to ask you, I'm going to state, you were previously sworn in. Do you understand you're still under oath? You don't have to stand and get sworn in again. Do you understand?
Yes, yes, Your Honor.
All right, Ms. Moore, is the defense ready to proceed?
We are, Judge.
Mr. Nelson, are you ready?
Yes, Your Honor.
Mr. Nally, are you ready?
Yes, Your Honor.
All right, let's please bring the jury.
Jury entering.
Ms. Moore, does the defense acknowledge the jury? Yes. Mr. Nelson?
Yes, Your Honor.
Mr. Nally, state.
Yes, Judge.
Mr. Nelson, you were previously sworn in. Do you understand you're still under oath?
Yes, I do, Your Honor.
Ms. Moore?
Okay, Mr. Nelson, when you testified before, I neglected to ask you a couple of questions you wanted to be asked. Is that correct?
Yes, yes, Attorney Moore.
Okay. The first one has to do with, we were talking about your colostomy procedure and that letter between the warden and Senator Sanders. Is that correct?
Correct.
Okay. Did Warden D.L. Young offer you an agreement in regards to your colostomy contradicting what he laid out to Senator Sanders?
That's exactly what he did. On December the 6th, 2016, I was brought into an office at the Federal Correctional Institution in Beckley, West Virginia. And I was brought into a room with about 8 Federal Bureau of Prisons officials, which is a very rare thing. An inmate is alone with these top-ranking officials. And they offered me a deal. Prior to that, in April, when I had this surgery, they told me it would be 2 months until I got the colostomy reversal. You know, the surgeon said, here, you sign here, you get a temporary colostomy, and out you go, 2 months, you'll be taken care of. Well, the BOP wouldn't send me, even though the Dr. Stewart at the outside hospital, private hospital, he kept calling for me, well, send the inmate. They wouldn't do it. 3 times they wouldn't do it. So finally, now I'm 2 weeks to being released. And I'm throwing a stink up. I mean, I'm really making some noise. And so they bring me into a room on December the 6th, 2016, and they said, listen, Nelson, this is the deal. That Senator Sanders thing, I was supposed to get both. I was supposed to get the reversal colostomy and a halfway house. I've been homeless before, as testimony's been heard, and that doesn't work out too well for me. So they offered me a deal. They said, listen, Nelson, if you want that reversal, that colostomy operation that's going to cost us $30,000, if you want that, we're going to hold you here on a medical hold way past your release date, and you're not going to get a halfway house. You're going to be homeless. We're going to send you to Orlando, Florida, and drop you off on the street corner, and toodles to you. I mean, what am I going to do? 6 felons on my back. Okay? Or we'll let you go now. We'll send you to that nice little halfway house in Orlando, Florida. We got it all set up for you, Mr. Nelson. But no colostomy, no $30,000. We don't know. And that's what they did. And of course, I went to the halfway house, but they sent Freedom of Information Act exempt memorandums to the people that run this halfway house here in Orlando, whom, by the way, are contracted by the Federal Bureau of Prisons. It's basically, it's a kind of like a jail it's a furlough, and they hold people there. Okay, bottom line is this, is that the memorandum they sent along with them was, hey, give them a hard time.
Okay, so to be clear, the agreement or deal that you were offered was to either choose to remain in custody well past your original release date in order to get the second surgery, or you could choose to be released to a halfway house and not get the second surgery. Is that correct?
Right.
And if you chose to stay in, you also were not going to get to go to a halfway house. Is that correct?
That's correct.
Okay. The second question you wanted the attorneys to ask you was, how has being treated the way that you were treated in in the Federal Bureau of Prisons affected you?
In the Federal Bureau of Prisons, after 25 years in prison, you go through such extreme situations in every shape, manner, or form. I mean, you're locked in cells with extreme temperatures of cold and heat, insects, bugs, pigeons, rats, roaches, horrible food, abuse from staff, and that's the short list. And I've had over 200 cellmates, some of the most dangerous people in America. I've had cellmates, the guy who blew up the World Trade Tower, the South Tower in February of '93, the LA Ad. I've had guys that have chopped up.
Your Honor, I'm going to object to non-responsive.
Okay.
Just
Same
again,
objection.
Mr. Nelson, if you could just focus on how it has affected you.
Yes, Attorney Moore. I'm sorry. How it affected me is this. After 25 years, if the jury sends me...
Your Honor, I'm going to object to non-responsive.
I'm trying to respond.
I'm going to overrule the objection at this point.
If the jury is to send me to prison with life with no parole...
Your Honor, again, I'm going to object to non-responsive.
I'll sustain the objection.
How has your mental health been affected by your previous incarceration?
I am a homicidal maniac.
Judge, I don't have any other questions.
Cross-examination?
Mr. Nelson, do you want to be sentenced to death?
Yes.
I'm going to object. That's an improper question.
I'll sustain the objection. Any other cross?
None, Your Honor.
All right, members of the jury, in just a moment, we're going to take a brief recess. During the recess, you're going to leave your notepads in the pens here. During the recess, you're under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. Please follow the deputy in the jury room. We'll bring it back as quickly as we can. Thank you. All right. Mr. Nelson, you can go back to defense table.
Yes, Your Honor. Thank you.
Judge, I'm sorry, may I approach the clerk with what's an identification?
Yes.
are?
Yeah.
All right, Ms. Simmons, at this point, is the defense going to rest?
Yes, Your Honor.
Mr. Nelson, do you agree with that decision?
Yes, Your Honor.
And Ms. Hicks, you're going to be calling the first witness for the state for rebuttal?
If we can just have a moment, Judge.
Sure.